Hello, everybody. Craig DeLuz here on behalf of the Firearms Policy Coalition, and you are watching Coffee with Craig. So please take a moment, sit back, relax, make sure you got a nice hot cup of coffee, and remember, like and share this program so that your friends can know where you're at this morning. Also, please take a moment to subscribe to our YouTube channel as well as follow us on Facebook if you haven't already done so. And also make sure to hit the notification button so that you can be alerted as soon as we go live. Also, please want to remind you, please go to fpcgear.com, fpcgear.com, cool place to get all sorts of pro-Second Amendment swag, and know that every penny that you spend goes right back in the fight for our right to keep and bear arms. So you can support the Second Amendment, and you can look good doing it. That's fpcgear.com. All right, you know, they say that the sun shines on a dog's ass some days, and such was the day in California yesterday, where our version, or California's version of the red flag law was actually, there was a bill before committee to actually expand it. That's right, they wanted to further expand the ability of who could request a gun violence restraining order here in the state of California. In fact, why don't we let the author, Mr. Phil Ting, why don't we let him kind of explain to you what his bill does and why he believes members should support it.
Thank you. AB 61 is a bill I brought forward last year, hoping that we have a new administration who will take another look at this piece of legislation. AB 61 expands the type of people who can obtain a gun violence restraining order. The gun violence restraining order was first passed into law in 2014 and then actually implemented in 2016. As we've seen this legislation and this law be implemented, we've seen its effectiveness. I really do need to commend in particular San Diego City Attorney Mara Elliott, who has really worked hand in hand with law enforcement to aggressively take guns temporarily out of the hands of individuals who probably really shouldn't be possessing them. This legislation expands who can ask for a gun violence restraining order from the court to temporarily take a gun away. Currently, the definition falls with family members as well as with law enforcement. This would expand it to people who are coworkers, employers, as well as people who you go to school with, so administrators, teachers, professors. And the reason is we've seen far too many school shootings as well as workplace shootings. We saw also in this situation in Ventura County, where we had actually law enforcement individuals who could have taken the gun away, interacted with the gunman, and then did not move forward with it, unfortunately. What we do know is the Governor Brown had a veto message that he thought that people should work through law enforcement. We don't disagree with that, but this allows people the option if after discussing the issue with law enforcement's not interested in moving forward, they have a right to go to court to petition the court, petition a judge, and again, it's petitioning a judge. It's a very standard process that people use also for domestic violence restraining orders.
All right, so let's be clear. So first thing is, he's advocating for people taking guns. He's talking about the San Diego City Attorney who is aggressively taking people's guns. Now he's saying temporarily, because they're so dangerous, they shouldn't temporarily have their guns. Well, if they're that dangerous, why are you looking at temporarily? Because chances are they probably aren't really that dangerous. Notice there's no information, by the way, at all in this hearing that is provided in terms of how many times they wind up having to give the firearms back. There's no evidence, nothing submitted in this testimony to that effect at all. Notice he also compares them to domestic violence restraining orders or to temporary restraining orders. And there's a problem with that. There's a problem with comparing it to that. And I think that the next group, which, by the way, is a group that you probably wouldn't think would oppose a gun measure or a democratic measure, and that is the California Civil Liberties Advocates. Now, here's what they had to say about their concerns relating to this particular measure.
So, Maddie Hyatt, California Civil Liberties Advocacy. I have not personally prepared a detailed analysis of this bill, but I know how our board members feel about it. One member used to work for an incubator program where people would come in and request TROs all the time. He stated that he felt they were so easy to get that it was just almost guaranteed, that people could get a TRO granted on affidavit alone. And so he wanted me to share that with the committee, and this does stay on a person's record well beyond the fact. So I know that those are some concerns expressed by our board, and so we are regretfully in opposition.
All right, so I'm going to take the 2 points that he made backwards. One is that this stays on your record. In other words, it's not like the fact that if someone got a gun violence restraining order against you, it doesn't still stay on your criminal record. It's a part of your permanent record. You are now permanently smeared. Even if it gets lifted, even if after 21 days you are not deemed to be, you go to court, you spend the money on an attorney, on a psychiatrist, you do everything that you're supposed to do. It still stays on your record that someone was able to get this. Now, the other thing is like he said with attorneys, one thing, they always compare these to temporary restraining orders, domestic violence restraining orders. And the other thing that they don't tell you is that how easy these are to get. Think about this. Who wants to be the judge who says, no, I'm not going to issue this temporary restraining order? And then someone goes out and shoots somebody. Who wants to be that judge? Guess what? None of them want to be that judge, especially when you start talking about how many anti-gun judges there are here in the state of California, right? So let's just be clear that this is a permanent mark on someone's record that will follow them forever, and it's a mark that quite frankly is very easy to get. Now, one of the best testimonies, one of the most impassioned testimonies. In fact, when you hear this, you're going to sound that there are a couple of things that are not similar to anything I would ever say, but there are a lot of things that you're going to hear this next person say that, it's going to sound eerily familiar. Check it out.
Unfortunately, we do think that this bill would undermine people's due process rights. We are not opposed to gun control measures that protect people's due process rights and civil rights. We are not opposed to even removing guns from people who pose a danger to themselves or others, provided that there are non-discriminatory criteria involved and that there is sufficient protection for due process. We did not oppose the creation of the GVRO system in California. This bill would significantly broaden the categories of people who can seek those restraining orders. As we've heard from one of the proponents, that some people are closer to their coworkers than they are to family. That is true of some people. It is not true of all people. There are people in California with tens of thousands of coworkers. And under this bill, any one of those people could seek a gun violence restraining order. Yes, there is a judge involved, but this process involves one side. One side petitions the judge. The judge only hears one side. They do not hear from the other person. I'm referring to the ex parte restraining orders. And the other person, not only are they not there, they don't even know that this is taking place. The only way that they find out is that an officer shows up at their door to confiscate weapons. These are people who have not been accused of a crime. They have not been accused of making criminal threats. They've not been accused of committing violence. And they may not actually possess any firearms. But when an officer comes to their door expecting to find someone who may be dangerous and someone who possesses firearms, we are concerned about how that encounter might happen and whether that might lead to a search of that person's house. So our concern is not necessarily with a person losing their firearms for 21 days. It is also about the search that might take place, that we feel like that would happen without sufficient due process. I also wanted to note that regarding the schools, this would allow an employee at a school who had been there in the past 6 months, who had encountered the student in the past 6 months, to seek an ex parte gun violence restraining order. The whole purpose of an ex parte order is the urgency of the situation. And so the fact that a person might not have encountered a student for 6 months seems to not be consistent with the urgency of these types of restraining orders.
All right, so who you just heard was a representative from the ACLU of Northern California. Now, mind you, I did not write that script for her because obviously she said they're not opposed to taking guns away from people, and they're not opposed to gun control that protects civil liberties, which we all know most of them do not. But the point that was made here is this, is that I realize you guys are saying, well, the ACLU, but here's the thing. We're not just talking about gun rights here, folks. We're talking about due process rights. We're talking about the fact that an individual, right, that an individual they don't get their day in court. They don't get to face their accuser. They don't get to present their own evidence before they lose their rights. It's all afterwards. And then they're sent, they may not even own a gun, but guess what? Law enforcement is sent to their house to search their home, their place of business, wherever they might have a gun. They're sent there to search for weapons. They said, look, this person is a danger to themselves or others and should not have guns. Go get their guns. And even the ACLU recognizes how bad an idea that is. Now, it's kind of funny, though. The chairman of the committee, Mr. Brian Jones Sawyer, talked about how, it was interesting because only in California could they get the ACLU and the gun rights organizations to stand together and to sit together and be in agreement. Well, Mr. Jones Sawyer, let me just tell you, it's because what we're talking about here is civil rights. Now, the ACLU may not necessarily see every civil right as equal, but we do.
In California, we actually treat people that are arrested for a crime better than we do people who someone thinks that maybe they are a danger to themselves or others. When you're arrested and taken to jail, you've got 24 to 48 hours before you have to go and get an arraignment, so you have your day in court quickly. In this case, you have 21 days where justice is delayed. And as Martin Luther King said in Letters from Prison, justice delayed is justice denied. And that's exactly what's going to happen in this situation. One of the proponents mentioned that the worst case scenario is that somebody's guns are taken away for 21 days. No, the worst case scenario is that somebody's guns are taken away for 21 days and they needed them in their own homes or their own businesses to protect themselves, and they lose their lives because somebody filed this order.
The testimony of the civil rights organizations, the other civil rights organizations, were enough to convince Assemblyman Bill Quirk, probably one of the most anti-gun members of the entire state legislature. It was enough to convince him to not only just stay off the bill, but to actually oppose it. And here's why.
But just to have a random coworker say someone is at risk is just too, how can I say, somebody can be settling the score, they can be lying through their teeth. It just doesn't seem appropriate to me. I think it needs to, I could support the bill in a more narrow way, but not as it's currently presented.
Okay, now mind you, I hope you guys caught that real quick, because what he said was, I think this bill needs to die. He was about to say this bill needs to die, but he didn't want to offend his fellow Democrats. So he did not kill his bill. Now, mind you, recognizing that, now this is before any of the votes, recognizing that his bill was now on the ropes and that his legislation may very well die in the very first committee hearing. I mean, we're talking, this is where they're supposed to be showing each other the love. In the very first committee hearing, his bill may die. So what does he do? He resorts to the same thing that they always do, but it's the children.
If you can imagine, as a parent of a fifth grader, to have a teacher have to talk to a group of fifth graders about what to do in the case of an active shooter. Okay, this is not a prison. This is not a juvenile hall. This is not a facility that should be anywhere at risk. But the fact that it seems every week goes by and we seem to have school shootings, and that our schools in this country aren't safe. What does that say about us as a society? What does it say about us as a legislature? That if we're not doing everything possible to make our school children safe, I don't think we're doing it.
He doesn't think they're doing their job. Folks, let's be clear. He doesn't support the idea of school resource officers in school. He doesn't support the idea of allowing teachers who have concealed carry permits and want to carry and want to be a part of their active shooter response plan. He doesn't support that. No, he's not putting more money in schools. He's not supporting the idea of more money, more facilities monies in schools in order to be able to beef up security and make sure that the campuses that students are going on to are the ingresses and ingresses, where people come and go, are limited, where they can keep an eye on people. He's not supporting any of that, because those are things that you could do that might actually make a difference and make schools safer. No. He's not supporting the idea of keeping criminals in jail. No, he's not supporting any of that. He just wants to take guns away from people. And he wants to cut law enforcement out of the process. He wants to make sure that someone can go directly to the judge and get a restraining order and get your rights taken away. Because, well, taking your guns is all he really cares about. As many guns as he can get out of as many people's hands. Because in their eyes, quite frankly, simply purchasing a gun is evidence that you are a danger to yourself or others. In any case, the final vote on the bill was 4-3-1. Now, you're saying, well, you're looking and you say, wait a minute, so how did it not pass? Because in the legislature, it has to be a majority of the committee has to approve it, right? So there's 8 members of the committee, 6 Democrats and 2 Republicans. Now, why do they do that? They do that so that in the event that they lose a Democrat, they'll be okay. So if all the Republicans vote against them and they lose one Democrat, well, then they'll still be okay, but they'll still have enough people to support it. Well, Bill Quirk actually voted no. Now, in the past, he's just laid off. He's voted no vote. But this time he actually voted off. And then another Democrat, I believe it was Rebecca Bauer-Kahn, actually laid off. So they lost 2 Democrats. So the 2 Republicans on the committee voted against it. 1 Democrat voted against it, and 1 Democrat laid off, which meant there were only 4 people for it, not a majority. Bill failed. Now, there's a good chance that the bill will probably be brought back up on what's called reconsideration. Now, reconsideration simply means that he gets a chance to go, fix it, or rediscuss it with members and then come back. I'm real interested to see. I don't think he can make changes that are going to get Bill Quirk on board, but he may go back and they may put some pressure on this freshman Democrat in order to try and get the bill through. So don't think that this idea is over. In the state of California, they also have the gut and amend. So just know this is the very beginning, but it's a good beginning. It's a good beginning because it just goes to show how far the anti-gun Democrats, the anti-gun members of the California legislature have gone. It's like we've done all of the quote-unquote common sense, the things that they would deem to be common sense. Now they're going after common nonsense. They're trying to introduce common nonsense and let anybody be able to go and take your gun rights. So anyway, it's a good sign from the belly of the beast, but know that the fight is not over on this or any of these other topics. Anyway, folks, I'm so glad that I got a chance to report this to you. I want to say that this happens also largely because you guys are out there, you guys are being active, and you guys are making sure that your voice is heard. So once again, thank you. Anyway, folks, that's going to be it for today's Coffee with Craig. We very much appreciate you guys tuning in. We appreciate you liking and sharing these videos and telling your friends about the Firearms Policy Coalition, because we are the home in the fight for civil rights. Got to use them or you're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.